May it please, Your Lordship, I beg to mention item number 9, Your Lordship. Your Lordship, the conducting counsel, Mr. P. Nongri, has some personal difficulty, Your Lordship.
Yes.
He's for
Respondent number 4, Your Lordship.
on pre-made by the respondent, not objected to by petitioner. List this matter to petition.
Much obliged, Lordship.
Lordship, I beg to mention item number 8, Lordship. Florida. Lordship, as per the order dated 16/11/2023, we have already corrected our typographical error, Lordship, in our petition.
You've given them copy?
Yes, Lordship.
Your
already.
Lordship, they filed the one extra small
This one
petition
taken
for
Lordship.
correction, only this one. And again they brought
Only
whatever
this page is
money paid, they have again in the prayer, the portion is brought
Same
on
only,
record.
Lordship, only the date, Lordship, we have corrected.
Have you counter check?
Just now I have received.
Just now we have, sir.
If everything is, I mean, as it is, except for the,
Already.
date.
Yeah, we have already filed, Lordship, rejoined.
Let the matter come
After
after
vacation,
vacation, Your Lordship. Your Lordship, can it be kindly after 3rd week of February? Just requesting, I'll be out of station.
But, let it come, and then if you can always request your colleague to.
Oh yes, Your Lordship. Because I am appearing as a private respondent. Your Lordship.
Anyway,
Yes, Your
you
Lordship.
may be,
Oh, yes, Your
even as private respondent, you have your
Yes.
colleague.
Yes.
So, I'm pre-made by the parties. This is matter after vacation.
Obliged, Lordship.
Much obliged.
Lordship, I beg to mention item number 2, my lord.
Item
Let it
number?
come up after vacation, my lord. Item 2, hearing list.
Have you
I have informed the other side, my lord. I have informed.
pre-made by the you are for the petitioner?
For the petitioner.
Pre-made by the petitioner. This is matter in the first week of February.
3 and 4 are connected.
5 also. Katuk 5 I pre-made by parties. This is matter after in the first week of February. Long keju again.
May I please, Your Lordship? I beg to mention item 6 and 7. I'm appearing on behalf of respondent number 6. I'm praying that this matter may come after vacation.
No objections, Your Lordship.
On pre-made by the respondent
Number 6.
6. Not objected to by petitioner. This is matter after vacation. This is those suspension matter.
Lordship, yes. After vacation.
Highly obliged.
Some supplementary cost list, item number 1.
Yes, Mr. Noru, tell me.
Your Lordship, I have, in compliance of your last order, Your Lordship, I have submitted my charge sheet, FIR and the depositions, Your Lordship, with a prior copy to the state, Your Lordship.
So tell me, what is your submission?
Your Lordship. May it please Your Lordship?
Yeah. So your submission is mainly centered around section 42.
No, Your Lordship, section 42 is one of my limb of my submissions. Mostly that the, if I may, Your Lordship, take you through the facts, Your Lordship. Yeah. Your Lordship, the petitioner in the instant case is the mother of the accused person, Your Lordship. The accused person herein is a driver by profession who drives a tourist taxi. So on the day of the incident, that is on 2nd of May 2023, he went to Guwahati to drop a passenger from Shillong to Guwahati airport, Your Lordship. After dropping the passenger there, while he was waiting there, an unknown lady came and approached him and requested him to deliver a parcel to Shillong to one person who will come and collect it from him. He agreed to the same for a certain amount of remuneration, Your Lordship, since he is a driver. And he did not know what is there inside the parcel since he did not open it, Your Lordship. So, after accepting that, while he was on his way to Shillong, he was stopped by some police personnel at around 10:45 p.m. outside Burneyhat Police Outpost, Your Lordship, on the allegation that he was carrying some drugs consignment. Thereafter, he was kept in the police station overnight, Your Lordship, and was formally arrested on the next day, that is on 3rd of May. FIR was also lodged on the next day, Your Lordship, 3rd of May 2023. Thereafter, he was produced before the learned court of the Special Judge NDPS Nongpo, and since then, Your Lordship, he has been languishing in jail for almost more than 7 months, Your Lordship. Subsequently, on completion of the investigation, charge sheet was filed by the investigation officer. Based on the charge sheet, charges were framed against him by the learned trial court under section 21B, which is intermediate quantity, Your Lordship, and 29 for conspiracy. Your Lordship, pursuant to the same, the learned trial court proceeded for recording of the evidence of the prosecution witnesses, and the same is still pending trial, Your Lordship. Thereafter, Your Lordship, the petitioner moved the bail application before the learned trial court, but the same was rejected, Your Lordship, by the order dated 16th of November 2023. I have annexed the order here, Your Lordship. I beg to mention herein, Your Lordship, that the co-accused in the instant case, who is facing trial along with this accused, has been released on bail by this Honorable Court, Your Lordship, by the order dated 16/11/2023. These are the facts of the case, Your Lordship. Now, if I may humbly submit, Your Lordship, that the accused person herein is merely a driver, Your Lordship. It is his regular course of duty to carry passengers, deliver goods from one place to another for a certain amount of fare. This is a regular course of duty. On that day, he was doing the same thing, Your Lordship. He was just acting as per the request of his customer. He did not open, they never opened the packet, what is to be delivered, Your Lordship. He did not know whatsoever what was there inside the packet. Your Lordship, he is just being implicated in this case, being made a scapegoat, and the persons who actually committed the crime, who are involved in this case, are still at large, Your Lordship. Further, Your Lordship, the accused person I would like to mention, Your Lordship, he is a single father of a minor child, Your Lordship. He has a son of only 9 years of age who is studying in Holy Cross School, Nongmensong, class 4. And Your Lordship, the mother of the child, the wife of the accused person, passed away in 2018, and since then he has been single-handedly taking care of the child, Your Lordship. So his further incarceration, Your Lordship, will impact the psychology of the child, cause him trauma, and affect his future, Your Lordship. Further, Your Lordship, the investigation in the instant case has already been completed, Your Lordship. Since charge sheet has been filed, trial has already begun, so his further custody for the purpose of investigation is no longer required. However, Your Lordship, moreover, Your Lordship, in this case, the quantity alleged to be recovered is only 46.47 grams, Your Lordship, which is an intermediate quantity. As such, Your Lordship, the rigors of section 37 do not apply to the instant case. As such, Your Lordship, there is no bar or restriction on grant of bail under section 37 of the NDPS Act in the instant case, Your Lordship. To support my submissions, Your Lordship, I am relying on certain rulings, Your Lordship, if I may submit, Your Lordship.
That is, you see, it's well settled. There are catena of cases with in that regard. If the quantity is not the main consideration, yes, except of course if it is commercial quantity, then the rigors of section 37 will follow. But if it is intermediate or small quantity,
Yes, 37 does not apply.
But the fact is that is not, it's not dependent on the quantity alleged to be to have been seized.
Yes.
To to allow the person to go on bail. There are other considerations like your complicity and antecedent and so on and so forth.
Yes, Your Lordship.
And what is your statement under section 164?
Your Lordship, under 164 statement was not recorded in this case, Your Lordship.
Not recorded.
Only 160 under 67 NDPS Act, Your Lordship.
NDPS is akin to, 64 is akin to 164 or
161, Your Lordship. 67 is as 161. 164 was not recorded in this case.
And what did he say under section 67?
Yes, Your Lordship. If Your Lordship kindly comes to page 47 of the charge sheet, Your Lordship.
Yes,
If I may read, Your Lordship.
please.
My name and particulars as stated above. I am a driver by profession, driven vehicle bearing registration number so and so. My mother's name is Srimati Kali Chetri. I have one sister, namely Miss Nisha Chetri. My wife is Lej Pooja Chetri. I stay with my family in Nauman Song. I am a drug user for more than 1 year. I studied till class 10 at St. Nanak High Secondary School. On 2nd of May 2023, I went to Guwahati for dropping passenger at Guwahati Airport. While waiting for Guwahati Shillong passenger at around 6:30 p.m., one unknown lady approaches me and requests to take along her parcel to deliver in Shillong, that one person will come and pick it up. On asking her name, she introduced herself as Mercy and disclosed her residence that she stayed near Guwahati Airport. I then opened the parcel and proceed straight to Shillong without passenger. On reaching Burnihart police outpost, I was stopped and detained by the police. On being asked, they told me that they will conduct checking on my body and vehicle. Accordingly, after some time, senior police officer and two public in civil dress arrived. I was asked by sub-inspector whether I should be searched in presence of the police gazetted officer or magistrate, and I willingly offered to be searched in the presence of the police gazetted officer. The notice under section 50 was served by SI L Pariong to me in the presence of two independent witnesses, and I put my signature on the body of the notice. SI L Pariong was first searched by the witnesses and nothing was found from him. Then SI L Pariong started conducting physical search on me and found one mobile phone named so and so, bearing IRN number so and SIM card bearing number so and so.
Skip the unnecessary details.
Yes, Your Lord. The SIL Pariong and team conducted search inside my vehicle and found 4 numbers of soap cases containing yellow powder suspected to be heroin was found inside the vehicle dashboard. The police weighed it using digital weighing machine and it weighed 46.47 grams. The police team conducted test of the powder which they found in the presence of the senior police officer, witnesses in my presence, and after test informed me that it is heroin. The police team seized it in my presence and I put my signature on the body of the seizure list. Your Lordship, I will come to the next para, Your Lordship. During further interrogation, he stated that I had collected the consignment from one girl by the name Miss Mercy somewhere from Guwahati airport site. Also, I had contacted a girl over the phone. I was asked to come near the airport site to collect the consignment and was asked to deliver in Shillong, but she didn't provide the number of the person who was supposed to collect the consignment from me at Shillong. That's all I have to say. This is his statement, Your Lordship.
Is this supposed to be the conduct of a prudent person?
Your Lordship.
Supposed to collect a consignment?
Yes, Your Lordship.
So it stands to reason that he is to deliver it somewhere.
He has to deliver it somewhere, Your Lordship.
Then how can it be that he has not been given the name of the consignee?
Because, Your Lordship, he has stated in his statement that the lady told him that the person will come and collect it from him, Your Lordship. Because normally what we do, Your Lordship, even if we send a parcel, then we inform the driver, Your Lordship, that you wait in PB or somewhere, our person will come and collect it from you.
Any CDR report?
There's no... There is no CDR report, Your Lordship.
Charge sheet has been filed.
Charge sheet has been filed, Your Lordship.
Yes, Mr.
Amit, this is your Lordship. Lordship, the fact remains that almost 47 grams have been recovered. As of now, your Lordship, there are altogether 8 witnesses and 4 of them had already been examined and cross-examined, your Lordship.
And what does those witnesses say? Any anything can be gathered from their evidence that
Lordship, yes.
to link the
Lordship, yes. Lordship, yes. If Lordship kindly have the deposition of PW1.
who's PW1.
He is the informant, Your Lordship. He is a police officer, informant. Lordship, his statement is very clear, Your Lordship.
As far as seizure is concerned, he will say so.
Lordship.
As far as the seizure is concerned,
Lordship.
so he will affirm that the
Lordship, yes.
alleged
Lordship, even the Lordship PW2, he is also a witness to the seizure, Your Lordship. And then PW3 also same, Your Lordship. And PW5, Your Lord, PW4, Your Lordship, is also a seizure witness, Your Lordship.
but the court would like to know and understand the link between the accused here and the said lady who, according to him, she was the one who supplied. If there's a link there, if they had any previous association, so the CDR would show that, you see, but you have not produced the CDR. You have seized his mobile.
Yes, your mobile has been seized, Your Lordship. There is no CDR or anywhere in the charge sheet has been mentioned the
CDR
previous
should have been
association.
Lordship, kindly see, Your Lordship. The FIR is very clear, Your Lordship. He was carrying that illegal contraband, Your Lordship. Illegal contraband on being handed over by a lady, Your Lordship. Kindly see, Your Lordship.
The argument is he is not conscious or he doesn't know what the consignment is. That is his argument.
Lordship, whether at this time, Your Lordship, whether that is a matter of evidence, Your Lordship. It's a matter of evidence, Your Lordship. So far, at this stage, at the juncture, Your Lordship, prima facie, Your Lordship, the accused person here in Your Lordship, he's guilty, Your Lordship, of the offence, Your Lordship.
Your Lordship,
everything has been seized from his possession, Your Lordship. It is for the accused to show that he's not guilty, Your Lordship.
Question of section 37 is
not applicable in the instant case, Your Lordship.
But can you see, Your Lordship, the availability of drugs, Your Lordship, in the society, Your Lordship?
You see, that is a different. We know that, we are aware.
In fact, Your Lordship, Your Lordship also only a day before yesterday had dealt this issue, Your Lordship.
I have dealt with this.
Yes, Your Lordship.
I remember. You see, observation was also made as to the menace of, you see, the drug situation here.
Lordship, yes.
That has been dealt with, but you have to also look at particular cases, facts and circumstances. If as has been submitted, he is a driver by profession, and a driver can
Lordship,
he can pick up passengers or he can pick up consignments.
Most of the drug we have been brought from outside into our state, Lordship, are all drivers, Lordship. Lordship, a driver, a prudent driver, Your Lordship, if he's a driver, if I give him a bomb, Your Lordship, whether he will carry without asking, Your Lordship, what is this? I give him a bomb, you please take this and hand over to this person or that person. Will he remain silent, Your Lordship, without asking what is what kind of parcel I have to take, Your Lordship? Lordship, so far that, Lordship, that is my humble and respectful submission, Your Lordship. That is a matter of evidence to be adduced by the accused at the time of at the right time before the trial court.
Even I am agreeing to that, Your Lordship, because the accused is facing trial. My only prayer is for enlarging the accused person on bail till the disposal of the case, Your Lordship. If he is found guilty after completion of the trial, he will serve his sentence. But Your Lordship, if in case he is found innocent, the state, the respondent, has no way to compensate for the life which he has served inside the jail, Your Lordship. or his minor child has lost in his absence of his father, Your Lordship, if he is found innocent. That will be decided by the trial court after examining all the witnesses, Your Lordship. We are ready to face trial, Your Lordship.
You are referring to some decision?
Yes, Your Lordship.
But I'm surprised at the absence of CDR, Mr. Shulai.
This has been dealt with.
Mr. Shulai? I said I'm surprised at the absence of CDR here.
Lordship,
That would be, see, that would be a factor which will clinch your case. See, to associate the accused and the co-accused.
Lordship, Lordship will kindly appreciate the fact, Your Lordship, perfunctory investigation also cannot be a crown, Your Lordship, to discharge or to acquit.
That would be, see, that would be at the see, in course of trial. But
It may
you
be a
also
defect.
you have to understand. See, I believe. See, I believe that every police officer who has been trained, as far as investigation is concerned, he knows what is to be done. We don't have to teach him. The police manual is very clear, or his training is. These are important factors.
Lordship,
These are important factors. What see that would play in the mind of the court or any officer for that matter. You fine.
If I may, Your Lordship. Your Lordship, in the order passed enlarging the co-accused on bail, Your Lordship, by Your Lordship has taken into consideration the case of Rakesh Singh versus State of West Bengal. Your Lordship, in that case, it is specifically mentioned that even assuming that the petitioner had dominion or control over the contraband in question, even if he was having control, Your Lordship, admittedly intermediate quantity of 76 grams of cocaine was seized. It was urged on behalf of the state that the statement of witnesses would indicate that the petitioner was a regular purchaser of contraband items. However, the fact remains that in the present case, only 76 grams of cocaine is involved. As observed by the Honorable Apex Court in the case of Samiullah, where intermediate quantity of narcotics is involved, it may not be justified to apply the rigors of the provisions of Section 37 of the NDPS Act relating to grant of bail. Even if he is found in conscious possession, or he was on control.
You mean to say that everyone who is found in possession of intermediate quantity should be
No, Your Lordship. But I'm saying that the fact is being raised that he was driving, he was in possession, it was seized from him. So I'm relying on this, Your Lordship. This was also upheld by the Supreme Court. I have submitted that judgment also, Your Lordship. This judgment, Rakesh Singh, was also upheld by the Supreme Court.
Yes, of course, it may have. But you see, like I said, each and every case, you know very well.
Yes, Your Lordship.
What is the jurisprudence in this area? Where
you are referring?
every case will depend on its peculiar facts and circumstances. Decision of Apex Court has to be viewed in that context. What are the relevant paragraphs? Have you?
Your Lordship, I was reading the extract from Your Lordship's judgment.
No, that is okay.
Yes, sir.
That is noted. And these other cases?
Your Lordship, the other case is where the case, this Rakesh Singh was upheld by the Supreme Court, Your Lordship. The relevant para is at...
What is the case where it was upheld?
State of West Bengal versus Rakesh Singh, Your Lordship. Order dated 11/7/2022.
Or this, of course.
Yes, Your Lordship. Because against that order, Your Lordship, the state filed an appeal before the Supreme Court, Your Lordship.
Relevant para? Where the case of Rakesh Singh was.
Yes, Your Lordship.
Same.
Paragraph
It was
16.4.
an appeal against that order.
Yeah, that order, Your Lordship. Same thing, Your Lordship. The appeal was dismissed and the order was upheld, Your Lordship. Your Lordship, another judgment is, Your Lordship, is a recent judgment of November 2nd, 2023, Your Lordship. Puranmal Jat versus State of Rajasthan.
Yes.
If I may read, Your Lordship. Leave granted, heard learned counsels for the appellant and respondent. The allegations against the appellant relate to commission of offences under the provisions of Section 8 and 15 of the NDPS Act 1985. Alleged recovery from him is about 35 kgs and 150 grams of Doda Posh poppy straw. The commercial quantity for poppy straw is 50 kgs. The appellant is in custody for over 7 months. Even my accused person is in custody for over 7 months, Your Lordship. Charge sheet has been submitted in the case. The recovered contraband item having weight less than the stipulated commercial quantity, the restriction on grant of bail under section 37 of the Act does not apply in this case. We do not think his continued detention pending trial is necessary in the given circumstances. We accordingly set aside the judgment under appeal and direct that the appellant be released on bail in connection with so-and-so, registered with so-and-so police station. On such terms and conditions, the special court may consider fit and proper, Your Lordship.
Upon the parties, I'll pass and see orders.
Lordship, that Lily Silthau, Your Lordship, that has been dealt by Your Lordship in this case, Your Lordship, Rupa Kurung.
On the point of possession.
Lordship, yes, Your Lordship. Take out that one. That has been dealt by Lordship at para 11, Your Lordship. Para 11.
Okay.
If I may read, Your Lordship.
Please.
In the case of Shrimati Lily Supra cited by the Landed Council for the petition, this court has considered the case of the accused person therein and has enlarged her on bail, even though the seizure of the alleged contraband drug was that of an intermediate quantity, but the fact that the said contraband drug has not been seized from the accused person in that case, the court has accordingly granted her bail. Therefore, the case has no relevance to the fact in the present case. But in this case, Your Lordship, the drug has been seized from this person. Lordship, I have other judgment also, if Your Lordship would.
Yes, please.
May I?
Yes, yes, please. Anything to support your case?
Para 5, Your Lordship. Para 5, Your Lordship. Lordship will kindly come to the below, Your Lordship, the purpose. The purpose for which the act was enacted and the menace of drug trafficking which intend to curtail is evident from its scheme. A person of section.
You are reading?
Lordship, paragraph 5, Your Lordship. Then, Lordship, the second paragraph, the purpose.
Yes, please.
Lordship. The purpose for which the act was enacted and the menace of drug trafficking which it intends to curtail is evident from its scheme. A person of the section 37, Your Lordship, leaves no doubt that in the mind of the court that a person accused of an offence punishable for a term of 5 years or more shall generally not be released on bail. Negation of bail is the rule, and its grant is an exception under section of 37. So, Your Lordship, my humble and respectful submission, Lordship, in a drug case, Your Lordship, the refusal of the bail is a rule, and jail refusal of the bail is a rule, Your Lordship. It cannot be enlarged on bail. Then, Lordship,
that is only because of the specification under section 37.
37, Your Lordship, yes. Then, Lordship, another, Your Lordship. That is 99, Your Lordship. Kindly come to para 7, Your Lordship. This also with Lordship 37, para 7. It is to be borne in mind that the aforesaid legislative mandate is required to be adhered to and allowed. It should be borne in mind that in a murder case, the accused commits murder of 1 or 2 persons, while those persons who are dealing in narcotic drugs are instrumental in causing death or inflicting death blow to a number of innocent young victims who are vulnerable. It causes a deleterious effect and a daily impact on the society. They are a hazard to the society. Even if they are released temporarily in all property, they would continue their nefarious activities of trafficking or dealing in intoxicant. Reason may be Lordship. Then another Lordship judgment is Lordship, kindly come to paragraph 12.
Yes.
The limit the limitation on the power to release on bail in section 437 is in the nature of restriction of that power. If reasonable ground exists for the belief that the accused is guilty. On the other hand, the limitation on this power in section 37, the Lordship, it deals with 37 of the NDPS Act, is in the nature of a condition precedent for the exercise of that power, so that the accused shall not be released on bail unless the court is satisfied that there are reasonable ground to believe that he is not guilty. Under section 437, it is for the prosecution to show the existence of reasonable ground to support the belief in the guilt of the accused to attract the restriction on the power to grant bail. But under section 37, it is the accused who must show the existence of ground for the belief that he is not guilty to satisfy the condition precedent and lift the embargo on the power to grant bail. Lordship, as I have submitted earlier, Your Lordship, it is for the accused to show that he is not guilty, Your Lordship. But in this present case, Your Lordship, kindly see, Your Lordship, contraband, illegal contraband has been seized from his possession, Your Lordship. So, in my humble and respectful submission, Your Lordship, considering the fact with the availability of drugs, Your Lordship, in our city, it is not a case for grant of bail, Your Lordship. Let him face the trial, Your Lordship. If the state cannot prove, Your Lordship, he will be honorably acquitted. Highly apply, Your Lordship.
If Your Lordship, if I may humbly submit, Your Lordship, the citations relied on by my senior here, all the three citations deal with section 37. And it is not a res integra anymore that section 37 do not apply in cases of intermediate quantity.
That is it.
Not guilty word has been used in these citations, Your Lordship, rulings. But not guilty word will not be used. That is used only once 37 is applicable. Because that not guilty word is provided in the statute, Your Lordship. Since this is an intermediate quantity, Your Lordship, at the time of consideration of bail, I humbly submit, Your Lordship, at this time it is not necessary in the instant case to come to a conclusion that the person is not guilty, Your Lordship. If it was a commercial quantity, I humbly submit.
Oblige, Your Lordship.
Obliged.
Only the thing, the judgment dealt, which has been cited by my friend, dealt with section 37 only, Your Lordship.
Exactly.
Apply, Your Lordship.
Announcement of judgment.
My brother will pronounce the judgment.
Only the last line. Well, in view of the discussion work, there is no merit in present writ petition. It is accordingly dismissed. Writ appeal. Writ appeal. Yes, yes. Present appeal. Okay.
Sign it then. Sign it. Just sign it. Let's sign it.
Daily cost list, item number 1.
Gosh.
But as per the last order, it was fixed for appearance of the of respondent number 2, failing which the case would proceed ex parte. That was the order.
And
Appears one of the
you had appeared for him earlier.
No, my lord. I had appeared only for Vikas Kumar. In the writ petition as well as here, my lord.
Dr. Muzika, you have said earlier that he has already been, accommodated or has got a job somewhere else.
My lord, this was the intimation which I received, my lord.
This is what was submitted by,
Or you have said.
Yes,
my lord, that he got a job in railways something.
Yes, my lord. In fact, he spoke to me also over the phone. But since I am not representing him, but that was the case, my lord.
Well, this fact wasn't because the judgment of the learned single judge, my lord, Vikas Kumar and others are good for the petitioner, Mr. Bhattacharya was the counsel, my lord.
Who's the counsel?
I'm only for Vikas Kumar, my lord.
Okay.
In fact,
No, but for the other
the
one?
fact that the petitioner number 2 is not interested in the matter is also reflected in the the learned single judge's order.
Okay. Then we'll proceed ex parte.
Ex parte, my lord.
This is a misapplication.
For continuation of 37 days.
How?
37 days.
How many days?
37 days. 37.
And what is the appeal?
But here, my lord, he applied for certain posts and agreements, my lord. Then there was subsequently change in the number of posts, my lord. He was waiting list number 1, my lord. One person resigned, my lord, after joining. So his claim is that being in the waiting list, I should be given an appointment, my lord. Basically, that is the case, my lord.
So is there
Our case is that a vacancy arising out of resignation, my lord, waiting list cannot be used for that purpose.
No, my lord.
That is one aspect of the matter, my lord.
Is there a policy in that regard?
Well, that is the law laid down by Supreme Court in several decisions.
But my lord,
That was one aspect, my lord. The second aspect was that originally the advertised number of vacancies were different, my lord. Subsequently, there was a corrigendum increasing the number of posts, and there was again a decision to reduce and bring back the number of posts to the original posts, my lord. So he is trying to make out a case for that.
Lord, that is not exactly the case. Lord, what had happened, my lord? There was an advertisement which was floated in the year 2007. My lord. Now, in the advertisement, my lord, there were 6 posts which were advertised. My lord, 4 for the unreserved category, that is the general category, and 2 for the scheduled
Tribe.
tribe. What had happened, my lord, pursuant to that, applications were invited, applications were submitted, my lord. But however, in the 2007 advertisement, nothing happened, my lord. It did not culminate into any appointment, my lord. Subsequently, my lord, in continuation of that advertisement, another advertisement was issued in the year 2017.
17.
Now, initially, my lord, when the advertisement was issued, the earlier vacancy, which is 4 vacancy in the general category, was reduced to 2, my lord. And my lord, so there were 4 advertisement for filling up the vacancy of 4 posts. So, my lord, in the process of the selection, my lord, prior to the publishing of the result, my lord, of the successful candidates, the department realized that there is a mistake, because earlier there were 4 appointments for the general category. So, my lord, they issue a corrigendum saying that for the general category there will be 4 posts prior to the declaration of the result, my lord.
So altogether it will be 6.
6, yes. So, my lord, as per that list, my lord, I am a qualified candidate.
Okay.
I am the 4th candidate in the in the select list, my lord. So thereafter, my lord, arbitrarily, suddenly the department struck down that corrigendum, my lord. So whether that can be done, my lord.
You mean to say that changing the rule
Yes,
of the
my
game?
my lord, once a selection process is over, can it be revisited, my lord? That was my case before the learned court below, my lord.
And our case is, my lord, posts were increased during the advertisement process, my lord, and again reduced back to whether he can
Initially,
equal
how many posts were advertised?
4 posts, my lord. Then this was increased to 6, my lord.
But my lord
Total.
will kindly see
Yes,
that the earlier advertisement, 2007, that remains, my lord. So those candidates, as well as the fresh advertisement, is 2017, both culminated, both were
yes, that is
participated together.
because they are part and parcel of the same
Yes, my
process.
lord.
no
So the
doubt.
department realized its fault. After realizing its fault, issued the corrigendum. This is my case.
So we'll hear the matter. Huh?
But I pray that the delay may be condoned, my lord, today.
Yeah, delay, of course. Delay will be condoned. This court, in its previous order, dated 29/11/23, has urged upon the respondent number 2 to appear before this court, but on his failure to appear, as has been observed in the previous order, this matter shall now proceed ex parte against such respondent. Heard Dr. N. Muziga, heard DSGI for the applicant. You have written appellant, should be applicant, isn't it?
But in this case, it should be applicable.
It's a I apologize, my lord. In para 1, I have said applicants, my lord.
For the applicant was submitted that the related appeal has been preferred for this court. Belatedly, for which a delay of 37 days has occurred. The prayer is made for the said delay to be condoned. Learned counsel for the respondent, Mr. K.P. Bhattacharjee, has no objection to the prayer made. Of this court, on consideration of the submission made and finding that the delay, the cause of delay has been suitably answered, prayer made is accordingly allowed. The condonation, the delay in filing the appeal is hereby condoned. Petition disposed of. Registry to diarize the appeal and number it accordingly. So we'll hear the appeal
After vacation?
Huh?
After vacation too?
You're not prepared today.
After prefer.
Will not be a very small issue, Dr. Machiga.
My lord, here basically why we have come.
I don't think once you start, we will allow you to argue more than 10 minutes.
My lord, what has happened, my lord, here? The learned singer just set aside the entire implement order, my lord. That is very good. But that will mean that we have to fill up all 6 posts, my lord.
It's okay. That can be, to that extent, if you say that, it can be corrected.
On permit by the parties. The appeal will be heard after vacation. No, put it this way, appeal will be heard in the second week of February.
On supplementary item number 2.
May it please your lordship. Lordship, I received the CD just now, my lord. If the matter could kindly come up at the bottom of the board, lordship, I'll just flag the relevant portions of the CD, my lord.
You're talking about bottom of the board, miss. We have only one more case left.
And I'm also there in the next case, my lord. I just received.
Okay, okay. I'll give you time. We'll take up the other matter.
Lordship.
Item number 3.
Lordship, in this matter, Mr. Nombri is appearing, but he's.
You tell me, Mr. Shala, what is the case about?
Your Lordship, may kindly take at the end of the board. So Mr. Nombri will apprise this court.
Lordship, if I may, this matter pertains to an order passed by this Honourable Court, my lord, on the 10th of October 2023, granting transit bail, lordship. So, lordship, the period is ending tomorrow, lordship, and there have been certain pleadings made herein which I have to confirm, lordship. So, since the period is ending tomorrow, I pray for time till Thursday. I may seek necessary instructions, and in the meanwhile,
Lordship, I humbly pray that it will be taken at the end of the board, because Mr. Nombri will. After this, I think mainless is there.
Mainless is there, of course.
Yes, after the end of the board of the mainless, Your Lordship.
Let's have a look how many more cases we have in the main list. Only one.
No, still, Your Lordship, I will try to talk to Mr. Nombri in the meantime. If not, then I'll apprise this court about the facts of the matter.
Oh, Mr. C, if Mr. Nobody has come.
Yes, sorry, my lord.
It's okay.
Mr. Alex in the other matter. My lord, we are before your lordships.
Yes, tell me.
My lord, if your lordships has my application, page 9, my lord, is the order passed by your lordships on 10th of October, granting me 60 days of transit bail, my lord. Ask for time.
I am appearing for Dr. M. Mosika. He is the complainant in the case. FIR was filed by him. He has to make some submissions. If the Lordship kindly takes up the end of the
Oh, this is where the two FIRs were filed?
Yes, my lord.
In Calcutta and
yes, my lord.
Clear.
That same matter, my lord. And your lordships in this particular application had granted me transit bail on medical grounds, my lord, and directed me on the 60th day to appear before the IO. So the day is tomorrow, my lord. I appeared on the 5th, and I get an email, which is here, your lordship, in the application from the IO himself, saying that you please come on 11th. 11th is Monday, my lord. So, my lord, now I apprehend, my lord, that something is going on. And, my lord, there's a judgment of October this year by the Honorable Supreme Court, which has settled this law regarding transit bail. And the Honorable Supreme Court, my lord, has observed that, yes, other high courts where the person resides have the power to grant transit bail to enable the certain person to approach the appropriate court for necessary bail. So all I'm seeking for by this application is, my lord, kindly extend the transit bail, my lord, period for another 60 days, my lord, or subject to whatever deems fit by your lordship. In the meantime, I will approach the proper court within the jurisdiction of Calcutta, my lord, to obtain my regular anticipatory bail, my lord.
But that was precisely the, I think the...
My lord, your lordships kindly have page 13, my lord. This is your lordship's order, which starts at page 9. At page 13, para 8.
Yes.
So your lordships had observed, as observed above, though grant of pre-arrest transit bail cannot be a matter of routine, the circumstances indicated by the petitioner, that is, on the ground of medical exigency, is found valid. The petitioner is accordingly allowed to go on transit bail for a period of 60 days from the date of this order. However, it is made clear that the petitioner shall not abuse the liberty given, but would confine his activities only to the extent of furtherance of his objective of getting proper medical treatment. medical treatment, my lord. From any place of treatment of his choice, it is made clear that at the end of 60th day, he is directed to report before the investigating officer, so-and-so, Howrah, West Bengal, my lord. So, my lord, pursuant to this, my lord, at page 15, immediately through the OC of Joy Police Station, transmitted this order and the condition granted by your lordships in the bail order. And email was also sent to them. And page 17, my lord, will have my medical records. I went for treatment to, my lord, Medanta, Gurgaon. I was admitted there, my lord, for 2 days, and I'm undergoing treatment. So I have complied with your lordship's order, intimated the IO also, and thereafter, my lord, I then issued another letter at page 21. Page 21. This is through the OC Joy Police Station, that to the IO, that I'm coming on 5th of December at 11:30 a.m. my lord, in compliance of the order passed by your lordships. And I also send an email at page 22 directly to the IO, my lord. Now at page 23 is a letter issued by the IO to me, my lord. This is through the OC Joy Police Station. This is to me through OC Joy Police Station. Kindly have on the right top, my lord, the date and the time.
Yes.
So he says, my lord, that you are hereby informed that investigation officer in the instance case is out of jurisdiction due to pre-scheduled engagement. Hence, IO is not available on 5/12/2023 to interrogate you. You are directed to appear on 11/12. Now, my lord, 11/12 is beyond the 60 days, my lord. So I have an apprehension because during the 60 days I was undergoing treatment. So, my lord, all I'm praying for is kindly extend this transit bail, my lord. I will, in the meantime, approach for appropriate, my lord, appropriate court, my lord, judgment of jurisdiction, my lord, within the Calcutta, my lord. And, my lord, if your lordships has the judgment of the Honorable Supreme Court, my lord, I have just handed over to the court master. This is, my lord, reported
No, you have to appear before the IO in response to a notice under 41.
Yes, my lord.
So 41A does not, you see, imply that you will be arrested.
Yes, my lord, but I do have an apprehension. If your lordships also sees the complainant is here, they don't have any right of audience, but, my lord, there's a lot of pressure. And this is a, my lord, matter which has travelled several places, my lord, up to the Supreme Court, also before this Honourable Court, my lord. So, my lord, there's a apprehension. So all I require is, my lord, some time for me to approach, my lord. Kindly have, my lord, the judgment which I'm relying on, my lord. This judgment was delivered on 20th of November 2023, very recent, my lord. Reported in 2023, SSC Online, SC 1484, my lord. I'll straight away take your lordships to the relevant portion, my lord. Kindly have, my lord, internal page. My lord, I can't see an internal page.
Just go to the relevant paragraph.
Paragraph is 103, my lord. I'll start from 2 lines from the bottom of 103 of this page, paragraph 103, bottom, my lord. In this circumstances, your lordships has bottom of the page, 2 lines, my lord. In the circumstances, we hold the Court of Session or the High Court, as the case may be, can exercise jurisdiction and entertain a plea of limited anticipatory bail even if the FIR has not been filed within its territorial jurisdiction, and depending upon the facts and circumstances of the case, if the accused apprehending arrest makes out a case for grant of anticipatory bail, but having regard to the fact that the FIR has been registered within the territorial jurisdiction of the High Court of Session Court, as the case may be.
Has not been registered.
Yes, my lord.
You say has been registered.
My lord, just kindly. Has not been registered within the territorial jurisdiction of the High Court, as the case may be, at least consider the case of the accused for grant of transit anticipatory bail, which is an interim protection of limited duration till such accused approaches the competent session court or the High Court, as the case may be, for seeking full-fledged anticipatory bail. So, my lord,
but here we have a case of 2 FIR, isn't it?
My lord, that has been quashed. That has been, my lord, that petition was allowed, and that FIR has been my lord, now transferred to the
Calcutta.
Calcutta, my lord. So both the FIRs are now before Calcutta.
I'm not aware of that, my lord.
The state was a party in that matter. It's decided by the other court, my lord.
Oh. So that came subsequent to the order passed by this court in this
Yes,
petition?
my lord. Yes, my lord. Subsequent.
So would that change the circumstances?
No, my lord. Because the FIR still remain, my lord. It's just the police station has changed. Investigating authority has changed.
And would that, you see, under such circumstances,
Would this court have jurisdiction, my lord?
see, would this, paragraph 103 apply in your
Yes,
case?
my lord. Yes, if I may read again, my lord, what it actually says. In the circumstances, we hold that the Court of Session or the High Court, as the case may be, can exercise jurisdiction and entertain a plea of limited anticipatory bail even if the FIR has not been filed within its jurisdiction. So, my lord, the FIR not being before your lordship's jurisdiction, your lordships can still entertain limited, my lord, anticipatory bail, that is for transit, till such time I am able to, my lord, approach the appropriate court.
that has been-
that is the purport, my lord.
That has already been
All be granted. So I'm only seeking for extension, my lord.
extension.
Extension, my lord. Only
May
extension.
I please, your lordship, if I may. Lordship, on the first occasion, this honourable court was pleased to grant the transit bail for 60 days, lordship. And on perusal of the records, in the month of October only, the applicant had been hospitalized and then also discharged on the 18th of October. That was within 8 days of the grant of bail. The remaining 52 days, lordship, what had prevented them from approaching the court in Calcutta for anticipatory bail, lordship? There's nothing on paper to suffice saying that the entire 60 days was spent in hospital. Only from 16 to the 18, lordship. That's my first point, lordship. Secondly, lordship, the judgment they're placing reliance on, this court has already gone into that, and that's why this honorable court has granted transit bail on the 10th of October, lordship. Thirdly, my lord, whatever medical reports they have placed before this honorable court, the same ended on the 18th of October. 19th of October till today, the 8th of December, nearly 2 months, my lord. What were they doing? They're just trying to seek some kind of protection under the transit bail on the plea of medical grounds, lordship, which should not be entertained by this honorable court. Because on the first occasion, on the plea of medical grounds, this court was pleased to grant order dated 10/10/23. Lordship, the applicant should not take advantage of the ground of medical grounds, lordship. So for this, I strongly object to the extension, my lord. They should have approached, because they had the time. They had the time to approach the concerned court in Calcutta for anticipatory bail, which they did not. And there's nothing in the application that reflects as to why there was no application before the concerned court for an application of anticipatory bail. There's nothing that is reflecting the same, my lord. So with this, lordship, I strongly object to any extension.
Lord, because, my lord, kindly again have page 16. This is what was, my lord, upon this honorable court passing the order on 10th, we immediately, my lord, on the 12th, my lord, we issue a letter, my lord, because in terms of your lordship's order requiring us to furnish a bond, personal bond of 30,000, we do write, my lord, to the IO and to requesting him to inform us on how to, my lord, execute the bond, and also on a date. Now, that was not being communicated. In the meantime, I was hospitalized. So, my lord, after I was discharged, I recover. I go to Calcutta, my lord, with due intimation. However, it is, the IO was not available on a certain date, has asked me to now to come on 11th. My lord.
My lord,
That is not, that's beside the point.
Yes, sir.
What was submitted by the senior advocate, senior GA, is the fact that you have ample time to apply for anticipatory bail from any competent court,
My lord, my lord. My lord, I was recovering, my lord. I was hospitalized. I was recovering, my lord. And my lord, before the end of 30th, my lord, 60th day, that is more than a week before that, my lord, I approached the IO. It was just unfortunate that the IO was not available on that date. It is only in such circumstances, my lord, we are only seeking for extension of a certain period, my lord, as deemed fit. We will do the needful, my lord.
My lord, if I may, the word
my lord,
due
the
intimation
merit-
was not done, my lord, because going through the records, lordship, due intimation means ample time. Here, the letter was given on the 4th. that I will come tomorrow, Lordship. Lordship, we know that the police have not just one case, many cases. Any person accused under any provision, Lordship, they should, if they are going to report before the police, ample time is not 24 hours or less than 24 hours, Lordship. So there was no due intimation, my lord.
My lord, kindly have page 15.
And it was like
Kindly have page
5, my friend. It was just 5 days, not even a week, my lord. Because today is the 9th. On the 4th, they said, we are going to come to before you tomorrow. Lordship, they are taking advantage of the transit bail, my lord.
Lord, page 15, immediately on the second day after your lordship passes the order, I have communicated to the IO, my lord. Immediately, my lord. Page 15, my lord. I have also, my lord, 2 days after grant of transit bail, my lord, at para 4, my lord, at page 15, I also communicated to the IO that in view of my medical condition, I am not able to physically be present. However, through video conferencing, I am still available today also to cooperate. Kindly have page 15, para 4, my lord. This is 12th of October, 2 days after the transit bail. I state, my lord, also if my medical condition is delaying the investigation, meanwhile to facilitate speedy investigation, I require you to kindly allow my compliance through video conference, which I can do and can do on any given day as per your convenience. It's not that we have not communicated, my lord. And the para before that, my lord, I say please advise the mode of such surety and in what name the same is to be furnished so that I can get the needful done. I have been in contact, my lord. It's not that I waited till the last moment. But the circumstances as on today is as such that now, despite my compliance with the order, within the 60 days, I appear before the IO. The IO now has called me beyond the period of 60 days, my lord. That creates some apprehension. So in terms of the latest law, my lord, which is my lord, decided in just recently, 2 weeks back, my lord, November 2023, that yes, a court within whose jurisdiction the FIR is not filed may grant a limited, my lord, relief.
You see, that
will have no bearing, my lord.
Exactly,
it was already complied with by this honourable court. No bearing, my lord.
We are on the extension, my lord. My lord, I will approach.
The principle is the same. So
yes, my lord. I will certainly, my lord. But principle. In fact, I wanted to indicate that what your lordships have held previously, and also in this case, it has been upheld by the Supreme Court. So as on today, my lord, we only require some time, my lord, whatever deemed fit to your lordship. Allow me to approach the Honourable High Court of Calcutta, my lord. Within a reasonable period, my lord, I will do that, my lord. And if your lordships grants me this extension of time, on 11th, I will be present before the IO, my lord. I will be present before the IO, as directed by the IO, on Monday, my lord. Limited prayer, my lord.
My lord, let them appear before the IO, but I pray that no order be granted for extension of the transit bail.
Then it serves no purpose, my lord. So some time may be granted. I will appear, my lord. I will also approach the Honourable Court.
What is the offence involved?
Well, 420, my lord. 420, my lord. I don't want to say this, but lord.
But lordship, they are taking advantage of the time given by this honourable court, my lord. That this should not please be set an example for other cases, lordship. They had 52 days to appear before the concerned court for anticipatory bail. Why didn't they do it? Nothing has been placed on the pleadings, my lord.
That is the only part you have not been able to explain yet.
Correct, my lord, because it was granted on medical grounds, my lord. So I was under the impression, my lord, since I have this transit bail, I will appear before the IO. But once the IO issued me that email, then I'm compelled, because this transit period is still available for me till tomorrow also. And off the record, my lord, off the record, my lord. In Meghalaya High Court, my lord, we file a matter today, it automatically comes up day after. In other big high courts, my lord, listing of matters is a big problem, my lord. So, my lord, kindly, my lord, since relief has been granted, some time, my lord.
52 days,
what is apparent is, you see, due diligence has not been, exercised on your part. You have slept over the matter?
No, my lord. In fact, we are already in the process, my lord. In the Calcutta also, my lord, we have engaged counsels. They are working, my lord, on the preparation and filing, which is still date not been complete. Here in Meghalaya, my lord, we are very prompt as young lawyers. We are able to file it overnight also, my lord.
Have listed the matter, lordship, within 52 days. 52 days, my lord. That's my very strong ground for objection.
No.
They are not a party
you are
here,
not
my
in-
lord.
So what do you have to say?
No right to audience.
They don't have a right of audience, lordship.
Even if your senior come, what do we do?
Exactly, my lord.
You are not. See, had you been a part of the proceedings, yes, you would have been granted an audience.
Not few days, my lord.
Heard Mr. Philemon Nongri, learned counsel for the petitioner, who has submitted that this court, by order dated 10/10/2023, in EB number 52 of 2023, concerning the petitioner herein, had on premise allowed the
My lord, sorry for interruption, my lord. My lord, can I just walk out a little bit? There's a matter.
yeah, it's okay.
My learned friend is here, my lord. But kindly consider my prayer, my lord. Deeply.
Had granted, had allowed the petitioner to go on transit bail for a period of 60 days from the date of the said order, essentially to facilitate his medical treatment outside the state of Meghalaya. However, there's also a direction by this court that on the 60th day, which happens to fall on 5/12/2023, he is to report before the investigating officer of Sankrial Police Station, Detective Department, Howrah Police Commissionerate. So I have to give the address. The Land Council has submitted that pursuant to the said order, the petitioner had accordingly proceeded for his medical treatment and was treated at Medanta, Gurgaon. This is Medanta, just simple Medanta, not hospital or
Gurgaon, Haryana.
Gurgaon, Haryana. Next, in compliance with this court's order, with the said order dated 10/10/2023, the petitioner had intimated the IO informing him that he will be coming to his office on 5/12/2023 at 11:30 a.m. in compliance with the notice issued upon him under section 41A CRPC. However, it is said that the IO, being preoccupied with other matters, has requested the petitioner to appear before him on 11/12/2023. Since the period granted by this court would expire on
The 9th.
9th
9/12.
on 9/12/2023. Therefore, the appearance before the said IO would be beyond the scope of the order dated 10/10/2023. Under such circumstances, the petitioner has petitioned this court to allow him to petition for this court for an extension of the set period of 60 days to allow him to appear before the IO on 11/12/2023 as directed. Ms. Angela Laret, Senior GA, appearing for the state respondent, has strongly objected to the prayer made by the petitioner and has submitted that the essence of the order dated 10/10/2023 passed by this court in allowing the petitioner to go on transit bail is not only to facilitate his medical treatment, but more importantly, to allow him to file an appropriate application before the competent court of jurisdiction in the state of West Bengal. However, records would show that the petitioner was admitted at the said hospital on 16/10/2023 and discharged on 18/10/2023, thereby giving him ample time to take necessary steps for any action to be taken on his part as far as the anticipatory bail or any petition for that matter to be filed before a competent court is concerned. This would only demonstrate the attitude of the petitioner, who has sought to take advantage of this court's order and has not taken steps in the right direction. Accordingly, even though this court may allow the petitioner to appear before the said IO on 11/12/2023, the prayer for grant of the prayer for extension of the transit bail may not be granted. Further submits the Leonard Additional Senior GA. This court, upon hearing the counsels. And on consideration of the submission made, would agree with the submission of the senior J that the petitioner has indeed failed to take necessary steps at the appropriate during the appropriate period of time that was granted to him by virtue of the said order dated 10/10/2023. However, as submitted, the offence alleged is 1 under section 420 IPC, and also considering the fact that the petitioner is undergoing treatment or recuperating from such treatment, due consideration would be accorded to the case of the petitioner. Accordingly, the prayer of the petitioner is allowed. The period of the transit bail is now extended for a further period of 10 days from today. It is made clear that within this period, the petitioner is to appear before the IO concerned. Petition disposed of.
My lord, just humble prayer if it can be 15 days, my lord, because it will take some time. Today's the 8th, your lordship. 15 days, your lordship, not 10.
On the 4th day, you have to appear.
Yes, your lordship. 11.
So you get 6 days after that.
Your lordship, 15, because it might take some time, your lordship, listing also. 15 days will be
fine. 15 days. Oh. Petition disposed of. Thank you.
Apply, lordship.
Daily costless, item number 1.
May I please the lordship? Lordship, I have filed the wakalatnama.
You file your
Wakalatnama, lordship.
what is it? Oh, that
Cancellation of bail.
cancellation of bail. So,
Lordship, this matter can be listed for hearing, Lordship.
you can hear it today.
Lordship, learned DSGI is on legs. This matter can come up after a week.
You file your power.
Yes, Your Honor.
Miss Counsel for the respondent has submitted that the power on behalf of the respondent has been filed, and accordingly, power has been filed. On such prayer, on such submission being made, the learned counsel for the petitioner, Union of India, has submitted that this matter may be posted for hearing. Accordingly, this matter is now posted for hearing. This is the same after petition.
Have your pleasure, Lordship.
Second call from supplementary costless, item number 2.
My lord, on 29/11/2023, your lordship was pleased to direct the prosecution to produce the relevant portion of the accused who has confessed under section 164 that I was the one who has given the contraband by 29/11/2023.
What is the amount?
15 grams.
15?
15 grams, yes. Your lordship. He has been in custody for last 10 months. He is 20 years of age. And 4 witnesses already examined. I was implicated.
Is he a user?
No, your lordship. I was, your lordship.
No, that's beside the point. In this case, he may be, but
I was kidnapped for ransom. I was kidnapped for ransom, and the charge sheet has been filed against the kidnappers also. And while I was kidnapped, and from in the vehicle, which was alleged that the vehicle belonged to the kidnappers only, and I was kidnapped. Information was passed. I was rescued by the police in the meantime, and thereafter the vehicle was taken to the Thana. In the night time, the vehicle was searched, and some contraband was found. From the that vehicle was not belong to me. It was belonged to the kidnappers, from where the contraband was recovered. And when the police asked one of the kidnappers, he said that it was me who has delivered to him. So, your lordship, on the basis of the statement, disclosure statement made by one of the co-accused, I was also implicated, although I am victim in the case, but I was implicated.
So the alleged contraband was seized from your person?
No, not from the vehicle of the kidnappers.
Okay.
It doesn't. The vehicle was not belonging to me. 2 vehicles were there. None of the vehicle belongs to me. I was kidnapped from Sonapur. I was put in the vehicle, and those kidnappers, they said that demand call was made for 5 lakhs, and in the meantime, information was passed also to the police that my relatives.
No, your any FIR file?
Yes, your lordship. On that day itself, police has admitted also that on that very day, when the kidnappers kidnapped me, after some time information was passed, and that's why police rescued me. The police rescued me, and Annexure 11 is the FIR, which of course information was passed, but the police sumoto has registered the case then and there. And then that time I was rescued, and thereafter contraband recovered. The search was conducted night time before in the Thana. And only I was implicated because one of the co-accused has said that it was me who has delivered the contraband of 15 grams.
So but you don't know any of the co-accused?
No, your lordship. Your lordship, these co-accused persons, I have no idea whether I know or not, but some of the co-accused, I think he was aware of, accused, but he was kidnapped from Sonapur, and he was, that part I am not aware, of course, but I think that he knows those.
See, the prosecution has to prove complicity.
Yes.
As to how you are related to the co-accused.
Yes.
If there are any indication that you are connected to them.
Yes.
Perhaps.
Yes.
But if you, as you say, you have been kidnapped, then being arrested would be a double jeopardy to you.
Yes. Charge sheet has been filed against the other accused also under section 364A. For kidnapping. Yes, for kidnapping. And those kidnappers, they have got bail also. I have, this is the order. And I am the victim, your lordship, but since I am inside, I cannot depose also. The kidnappers will also not be punished because police has not cited me as a witness. So I am the eyewitness.
Hey, have you brought anything with regard to that kidnapping case?
Yes, your lordship, that your lordship has passed this judgment that Lily, same it is applicable in my case also. Nothing was recovered from my possession.
No, I'm not talking about that. I'm talking about your, you see, your case of being kidnapped.
Yes.
That has been registered. So, is there any, material to show how investigation has followed?
Your lordship, in this case, in the same FIR, both the kidnappers as well as I am also being trying.
No, that is with regard to this particular case.
Yes.
But as far as the kidnapping case is concerned,
No, it is registered same
somebody
case. No, not separate case.
Same.
Same case.
That makes it easier then.
Yes. And Your Lordship, only the basis of my implication was that I have confessed. The co-accused has confessed, but there is no such confessional statement. That's why Your Lordship was pleased to call for 164 of the co-accused, which is not available, Your Lordship.
Yes, Mr. Talvi.
May it please your lordship. Your lordship, in this matter, the accused is a resident of Assam. Now, what had happened was he happened to be in Clearhead that day because he was a drug supplier, lordship, and he went to supply the heroin to these other 6 people, lordship, and they refused to pay the money. On their refusal, something transpired, and then they took him along, lordship. That is why he has been made an accused in the NDAPS matter, lordship. Lordship, all the statements are here, lordship, and what was recovered also. But to say that he was kidnapped for no reason, lordship, it's totally untrue.
No, for reason he was kidnapped, for ransom.
Not for ransom, my lord, because they refused to pay the amount for the drugs supplied by the accused person.
How rich is he?
It is the prosecution case itself, they have said that, Your Lordship, that demand was made. It is the prosecution case. Charge sheet is showing.
All the statements of the accused persons are there, my lord.
Can you lead this court to the relevant statement?
Yes.
Lordship, I have flagged the relevant statements, my lord, over there. And the prosecution also, they have...
Where is the...
Well, I'm so sorry. I just received it just now before the other
Your
item, my
Lordship.
lord. That's why I've just flagged whatever I could read right now.
In my petition
go
itself,
through
Your
this
Lordship, in my petition, Your
You
Lordship,
go
I
through this and
will...
assist the court?
Yes, Your Lordship.
Lordship.
Your Lordship, I will take Your Lordship. My petition I have enclosed, Your Lordship. 24, page number 24.
No, your case, I have understood your case.
No, the relevant portion, the statement, I have enclosed.
The only thing is that you have said that you were kidnapped.
Yes.
And then,
Nothing was recovered from me.
Nothing was recovered from you, but the alleged drugs were seized from the vehicle. You were,
in the kingdom.
You were there, and then after that, what?
And
follows is
one
you
more
were
point, Your
arrested.
Lordship, that vehicle was also searched after 2-3 hours.
But the prosecution story is a different version.
Yes, Your Lordship. Then thereafter, I let them show, Your Lordship. Then I will take Your Lordship to the statement, the evidence which was recorded. 4 witnesses has been recorded. Let them first.
Matter has been charged sheeted.
Yes, March 4 witnesses has been examined already.
Trial is ongoing, my lord.
So 161 statement is at this point has no relevancy, but I will take Your Lordship to the statement made in the court by the witnesses. I have enclosed.
Yes, miss, please.
First.
Lordship, may I have it after some time, my lord? I've just received, honestly, my lord, I just received it.
So I'll take a nap here.
I'm sorry, my lord, that's not my intention.
My lord, if I will just take Your Lordship to page number 42,
You can take, but I also have to assist the court, that's what.
Your Lordship, the prosecution may take 161, but I will take the real evidence which was recorded in the court.
You go through this. Let me hear what he has to
Yes,
say about this. What is the evidence?
Section, Your Lordship, page number 42. 4 witnesses, I will just take Your Lordship to that.
Yes.
This is the informer, who has registered, the complainant who has registered, this police official only, who has registered, who has lodged the FIR and case was registered on his statement. That is SI Sherkhan Buam. Now page number 44, Your Lordship. He is the eyewitness, but he is the one who has registered the FIR, lodged the FIR. Page number 44, Your Lordship, paragraph number 10.
Yes.
It is a fact that I was not present at the PO during the recovery of the suspected heroin from the vehicle. I filed the FIR as because I am the person who received the first information from Alam Chaudhary in the first part, and my superior officer directed me to include the fact in the second portion in my FIR. First portion of the FIR says that I was kidnapped. So he has received the information, he has lodged the FIR. And the second part, he has mentioned that contraband, regarding contraband, it was on the instruction of his superior officers. He has admitted in the cross examination. Number 12, when my senior directed me to enter in the FIR the fact in the second part of the FIR, I do it not arise to me to question them. So he did not question them, but since his superior directed him, so he included regarding the recovery of contraband. First information was only regarding missing and recovery of the person. So 14, Your Lordship, I was not present at the PO when the preliminary investigation was done. So he is the main person, your complainant. He himself is saying that I am not aware. Only I am aware that he was kidnapped and nothing was done in my presence. And 15 also, I have no knowledge about the preliminary investigation, but I was informed about it. He is totally hearsay witness as far as contraband is concerned. Now, Your Lordship, again I will take Your Lordship to page number 46. Page number 46. Paragraph number 21, Your Lordship. I did not witness the apprehension of the accused person and rescuing of the kidnapped persons. I was not present when the preliminary test of the contraband was conducted, and I did not witness the same. It is a fact that at the prayer in the FIR, I wrote the prayer to register a case against Banjab, Wanmi and others. This is the evidence of the complainant. Now, Your Lordship, page number 42 is the officer who has given the direction.
42.
48, Your Lordship, sorry, 48. PW number 2, he is Deputy SP, Crime. He is in examination in chief, next page 49. Relevant person only, Your Lordship.
Yeah.
He has, I want to impress before the Lordship that he is also hearsay. On initial interrogation, it revealed from Banjaplang Suklan that Masum Chaudhary had come to Sonapur to deliver contraband to them. However, the other alleged accused initially a statement were recorded, and it was confirmed from the other accused that indeed they have received contraband from Sri Masum Chaudhary, and thereafter the said accused person allegedly kidnapped Masum Chaudhary and fled away towards Clariard. Sri Masum Chaudhary on initial interrogation revealed that indeed he had brought contraband and delivered to it this one. This is, Your Lordship, they wanted to place that I have admitted and that other accused has also confessed, which they will bring. So this is totally, this witness is also, he has derived knowledge from others. He is also hearsay witness. So I am assisting, Your Lordship, because I am not suppressing anything, just that's why I am highlighting. Now, Your Lordship, page number 50. He is the officer who has authorized the person to conduct the search. 50, Your Lordship, cross-examination of Masum Chaudhary in para number 4.
Yes.
I construed it to the fact that Masum Chaudhary had delivered a soap box of heroin to Banjab and Wanmi based on their own admission before me during preliminary investigation, and as because the suspected heroin has been seized. So it is a mere assumption. This is just a mere assumption. He has construed that since they have said, that's why he is thought, but he is not eyewitness. And you will see 51, page number.
Yes.
Paragraph number 3. I did not visit the place where the suspected person and the victims were detained. So he is also, Your Lordship, will not going to help the prosecutor because he is also hearsay. He was not on spot and he was not seen anything that it was recovered from the vehicle or that somebody has confessed. There is no disclosure statement also he has recorded of the co-accused. He has not recorded any disclosure statement on oral. Now, Your Lordship, Your Lordship, PW number 3 is additional SP. He also, Your Lordship, has only has said in his examination in chief, page number 53, that during the preliminary examination, Sri Banjab Suklan revealed that he and his friend had tried to procure one box of heroin from Masum Chaudhary for a price of rupees such and such. However, after he made delivery of the box of heroin, they made a plan to kidnap him and to demand the ransom of rupees 5 lakh from his father. Further, Sri Banjab Suklan voluntarily admit that the sub box is present in the local taxi in which they were traveling, and that he is willing to show the police team where the sub box has been kept. So the prosecution case is based only on this, that during the investigation, one of the co-accused has admitted that he is the person who has delivered this one. So this is their case. But Your Lordship, he has also not exhibited any document or disclosure statement or any statement that yes, he has recorded that Banjab Suklan has admitted before him. No document has been exhibited through him in the evidence. No disclosure statement. So it is a statement, mere statement of this witness only. That means he is also a hearsay witness insofar as the recovery from Banjab. So this is the only hearsay witness. Now, Your Lordship, I'll just take Your Lordship 54 to show that when the this accused person were apprehended, and when the vehicle was searched. So this is very relevant because vehicle was also not searched immediately on the spot. Search was conducted at the Thana. Paragraph number 2, Your Lordship, of the cross-examination. At the bottom, the independent witnesses were called by OC of Clariat Police probably between 6:30 and 7 p.m. on the day they were detained. So 6:30 to 7 p.m. Your Lordship, because the person and the vehicle was also in their custody since 4 o'clock daytime. But why the independent witnesses, if the recovery was made, the recovery should have been made on the spot, because it was daytime only. Near DC office, independent witnesses also available. That time nothing was recovered, so the seizure was made very belated stage, and that too when the vehicle was already in the police custody. So it will also not going to help the prosecution. And to confirm this one, Your Lordship, I will just take 55, Your Lordship. Para number 8. I received the call from OC Clariat at around 4:30 p.m. informing that they have been detained, and it can be around 4:45 when the accused was brought to the police station. So 4:45, the accused was already brought to the Thana along with the vehicle. Now, one of the independent witnesses where seizure was made in the Thana, PW number 4, whose statement has also been recorded. It is in page number 56, Your Lordship. A relevant portion, Your Lordship, in page number 58. In 58, paragraph number 4, in the cross-examination. After I reached the police station, the police started to check the vehicle after 10 minutes. So he reached at 6 p.m. Vehicle was, after 10 minutes, vehicle was searched. And he has stated in para number 59, page number 59, Your Lordship, 59, paragraph number 4.
Yes.
I did not see who opened the dashboard and what was taken from the dashboard, but only when the box was taken outside the vehicle, I was shown and informed. So even if, Your Lordship, the trial will proceed, I have 4 witnesses already examined. Considering at this stage, Your Lordship, that there is a very bleak chance of conviction, Your Lordship, and that's why I was not pointing out my merits of the case, Your Lordship, but just for the sake of this bail application, I have stated, because it may affect also, maybe other witnesses come and they will see. But as of now, Your Lordship, I have made out of ground, Your Lordship, that I deserve at least bail, Your Lordship, because I am 20 years and I have been in custody for last 10 months. Other accused persons who had kidnapped me already enlarged on bail. And in the similar circumstances, Your Lordship has also granted bail in Lily, considering the circumstances that evidence and all Your Lordship has granted. Intermediate quantity, Your Lordship. I will not again repeat the same thing. Your previous bail application also, Your Lordship, already that all these things, rigors and all this will not attract. Only I am praying, Your Lordship, that 4 witnesses, there is no allegation, there is no previous case in the charge sheet, there is no such thing that I was involved in any other case. There is no reflection of case number, nothing. So the mere statement of the prosecution that I am the dog peddler without giving any previous criminal cases, anything to show that I was involved, at this stage, Your Lordship, just for the sake of bail, I deserve, Your Lordship, to get the bail.
You said the other co-accused have been
Already enlarged on bail,
Oh.
4 accused. There were 7 accused persons. 4 accused has already been granted bail, Your Lordship. 3 are still inside. And Your Lordship, since I moved the bail application before this Honorable Court was pleased to refuse, that's why the learned trial court is reluctant to give bail. So other accused also, they are not applying for bail. This case only, if I will get, maybe they can apply. But as of now, 4 accused person already granted bail prior to I come before.
And who are those 4 accused who have been?
Yes, Your Lordship.
Who are those 4 accused who have been released? Are they also part of
Yes,
the
yes,
kidnapping team?
kidnapping, yes, Your Lordship. I have given this, the order, bail order, Your Lordship.
It's here.
They were given bail, Your Lordship, on 12th May 2023. Although 364, Your Lordship, even if presuming punishment is higher than this intermediate quantity, the punishment for 364 is much higher.
No, these are all the
kidnappers.
Co-accused only in the case of
Kidnapping. Yes, that's why I'm not asking on parity, Your Lordship. I'm not. That's why I'm. Yes, I'm saying that kidnappers already released on bail. Of course, the punishment is more than this intermediate punishment for intermediate 10 years. Kidnapping for imprisonment for life or death also sentences.
I don't understand
That's why.
the connection.
Yes.
I don't understand the connection because this is NDPS. That's
No,
kidnapping.
I'm not saying connection. I'm not saying.
In the same case, both the
Lordship, exactly.
both things
Lordship.
are involved.
Yes.
So, of course, that is a different thing.
Yes.
It's for the prosecution to sort out.
Yes, yes. So, and the thing is that, Your Lordship, I have not been cited as a witness also. I am the victim, but that one I will take appropriate legal action. That is not my
We
case.
are not on that.
Yes,
I
yes.
think we are not on the
Not on that.
issue of
Oh,
kidnapping.
I'm not on that. So only considering what the prosecution has said that it was belong to me and all these things, a statement before the court has already come, and now 161 loses credence in view of the statement made before the court. That is only my submission is that, Your Lordship. So considering all this aspect of the matter, Your Lordship, trial is in progress. Nothing is there that I will abscond. I will furnish reliable surety. I will 20 years of age. If it is detained for long, Your Lordship, finally, if the matter will be decided, then by the time he will already suffer more than the punishment prescribed for this. Yes.
How many witnesses are there altogether?
10 witnesses, Your Lordship, and yes, 6 more. So it will take some time, considerable time, and I'm just praying for bail only. In the meantime, I may be enlarged on bail. I have also stated all the matter. I have not suppressed anything, Your Lordship. Yes, the prosecution has relied on the statement made by the court. Yes.
Lordship, this common order relied on by my friend may not be taken into consideration.
No, I'm not taking.
May not be taken into consideration at all, Lordship. Lordship, this is the second round for bail application made on behalf of the accused person, Lordship. And on the first round of litigation, Lordship, on the first round of the bail application, this court had noted that the submission of the petitioner on behalf of the accused son is based on merit. Prima facie on merit is seen that alleged contraband substance was recovered from the accused son of the petitioner. And he also has a nexus with the other co-accused person said to be involved in the case of kidnapping as well as in the drug possession of peddling. On this ground, the first bail application was rejected, Lordship. Now, my lord, my friend has also gone to the evidence taken in by the trial court with regard to the witnesses 1, 2, 3 and 4, Lordship. And he has stated that they all hearsay witnesses, Lordship. He himself has gone through the evidence, Lordship, at page 48, my lord, the evidence of the additional, DSP crime at page 49. Yes. On initial interrogation, it revealed that from so-and-so that the accused person had come to Sonapur to deliver contrabands to them. However, the other alleged accused initial statements were recorded and it was confirmed that the other accused, that indeed they had received contraband from the accused, and thereafter accused person, the other accused person kidnapped this accused person and fled away towards Cleariat. Lordship. So that is not hearsay, my lord.
No, this is hearsay. I have stated that.
Lordship. And then at his cross-examination, Lordship, at page 50, I construe it to be a fact that the accused person had delivered a soap box of heroin to Banjab Suklan and Wanmi Muksor based on their own admission, Lordship. Yes. This is on cross-examination. This was not shadowed by the cross-examination of the defense. Just let me complete. You'll have a chance to reply. Then thereafter, Lordship, at page 52, that is the statement of PW3, who is the additional SP, Lordship.
Which?
At page 53, my lord.
Yes.
During the preliminary examination, Banjab Suklan revealed that he and his friends had tried to procure one soap box of heroin from the accused person for the price of 22,000. However, after he had made the delivery of the soap box of heroin, they made a plan to kidnap him and to demand the ransom of 5 lakhs from his father. Further, Banjab Suklan voluntarily admitted that the soap box is present in the local taxi in which they were travelling and that he is willing to show the police team where the soap box had been kept, Lordship. And this soap box, the contraband tested positive for heroin, my lord. He is not a hearsay witness, my lord. He was present at the scene. I don't know where my friend got that term hearsay witness in concerning PW3, Lordship. So, my lord, based on whatever statement has been, whatever evidence has been adduced, Lordship, there is strong prima facie case, as has been recorded in the first bail application also, that he is a supplier, my lord. My lord, he has gone to the emotional ground that he's just 20 years old. what is a 20-year-old from Assam doing in Cleariat of all places, Lordship? We know that Cleariat is a hotspot. It's a transit port for drugs, my lord. We are all aware of that. And Meghalaya has the second highest number of consumers right now when it comes to drugs, Lordship. My lord, that also we go through the newspaper every day that drugs are being recovered, drugs are being burned by the police, Lordship. This is a crime that is ongoing, Lordship. And he is a regular drug peddler, my lord. Despite being 20 years old, what future awaits him? If he is not given a chance now, that is by serving due time for what he has done, if on bail, my lord, he'll go back to the same thing, to what he knows best. He's just 20, Lordship. So I pray that this honorable court may not be led on emotional grounds that he's 20 years old, but go into the details, especially in the evidence led, my lord, that this additional SP was present at the site when the contraband was recovered, my lord. And this is on evidence, Lordship.
That is why I say this court has made a query.
Yes, Your Worship.
As to whether the accused person is a drug user or not.
No, he's not.
If he's not a drug user,
He's not drug user.
then his case becomes more serious.
Lordship.
Yes, he's not drug user.
It's more serious.
Yes, yes.
And if he is classed in the category of peddlers,
Yes. Yes, Your Lordship. If I am classed, yes, peddling.
in the final analysis.
Yes. Peddling. If they will prove, then of course I will not be like. But as of now, what the evidence, whether anything has come, Your Lordship, that previous peddling means they have to show some cases that previously also I was involved. In the charge sheet, there is no mention that in such and such case I am wanted or something. Mayor saying that yes, I am peddling today, I will say no, I am not peddling. How the court will decide? If they are saying that yes, I was peddler, there has to be some cases. Previous cases has to be there. In mayor saying of the IO or the police that yes, he was peddling, and there peddling means there has to be some previous 2-3 cases at least. One case is also if they can show me.
It's not just a mere statement, my lord. These are the investigating of agencies. This is
on
not
the
a
second
marketplace
point-
that somebody will
second
make
point,
any allegation that one is peddling or not, my lord. They have gone through the procedure as established by law, Lordship.
If Your Lordship, they can just
And
show
this
that
is
where
at a very early trial, early stage. There are 6 more witnesses. It will not take much time, my lord.
early stage, Your Lordship, in the course of investigation, they can say that take their plea that early stage. Now, charge sheet has already been filed. There is no ground for saying
once charge sheet is filed
on merit.
Now the case is taken up on even a bail application would be taken on the merits of the case.
On the merit of the case, I am submitting only
and
on
you
merit.
have to show
Yes.
Fresh circumstances which would allow you to.
Yes, move this bill.
You have referred to according to you, the fresh circumstances would be
Evidence has been
on the basis
recorded.
of the evidence.
Yes,
that has been
before it
recorded.
was not there.
So
Evidence.
we will go by on that line.
Yes. So on that line, Your Lordship, that's why I have submitted that all the 3 witnesses, independent witnesses, of course, he was present when seizure was made at the police station.
It's just a seizure witness.
Seizure witness is the eyewitness. Hearsay witness means those who has learned from the others. This SP and all these things, they have learned from the
That's very
co-accused.
wrong. I think my friend did not go through it carefully. He's not a hearsay witness at all.
He has not seen that it was recovered from his position. Nah?
Go through the records first.
Your Lordship, I have already pointed out all these witnesses, they have said that they came to know from one of the co-accused. They did not see that I was delivering the contraband to the other person.
But you are not denying the fact that it was seized from the vehicle. You were there. Whether you kidnap or not.
No, I am that's why I have relied on the evidence of the PW number 4, Your Lordship, that the vehicle was already in custody of the police. That I do not know whether it was recovered or not. They detained me, and later on the vehicle was searched at around 6 to 7 o'clock in the night time. Whether I was present at that point of time, Your Lordship, before the when the vehicle was taken into and the vehicle was searched, I was inside the lockup.
Would this be the stage to hear such arguments, my lord?
No, evidence has been
is
recorded.
going on,
Evidence has been recorded. Evidence has been recorded. That means we have to go for as per the evidence only, Your Lordship, that vehicle was searched at 7 o'clock.
Fine. All right, Mr. Pandit, the counsel for the petitioner, who has submitted that the petitioner is the father of accused person Muhammad Masum Ahmed Chaudhry, that's his full name.
Yes, Your Lordship.
Who was arrested in connection with clear PS case number 10/2 of 2023. Why was charge framed against him? Against him under section 364A.
Against this accused, Your Lordship. Against my accused.
Yeah.
No, his
Lordship.
charges has been framed against him only under section 21B.
Under section 21.
D/29.
29 NDPS.
Yes, Lordship.
The Land Council has submitted that, has further submitted that this is the. Is this the second round?
Second, yes, Your Lordship.
Second
This
bail
is in fact third
Second,
round,
sorry,
Your Lordship.
second bail application.
And third also, Lordship.
Third
actually,
because
the trial.
first I approached this
Before this court.
Before the Honorable Court, second, Lordship.
before this third. One second, I withdraw, Your Lordship, because
Oh yes, withdrawn. I'm sorry, my lord.
first
One was withdrawn.
I came here before evidence. Second, I came before Your Lordship. Then Your Lordship directed me to approach the trial court.
So
And
this is
thereafter,
third.
now this will be the third. After the evidence is recorded.
Third bail application moved before this court with the same prayer, that is for grant of bail in respect of the said accused person who is in custody, who is in judicial custody for the last 10 months or so. Is also the submission of the Land Council that the case is now at the evidence stage and 4 out of 10 witnesses have got their evidence recorded. The fresh circumstances that is canvassed by the petitioner herein is that from the evidence recorded so far, a look at the deposition of the prosecution witnesses would show that almost all of them are hearsay witnesses and no one has in fact witnessed the seizure of the alleged contraband drugs from the accused person. Though there is in the evidence particularly though in the evidence the witnesses have deposed to the extent that the accused person is confirmed to be involved in a drug peddling ring, in as much as he is one of the peddlers who is working hand in hand with another co-accused, and since there is also a case of kidnapping registered wherein the allegation is that the accused person in question was kidnapped for ransom However, the prosecution story is that the accused person in question was allegedly kidnapped on the basis of a failed negotiation between the parties connected to the drug peddling matter. However, the Learned Counsel has reiterated that the accused person is not at all involved. He is an innocent person who was kidnapped for ransom and in the process, on being apprehended by the police, he was accused by the other co-accused of being part of the drug peddling ring. Nothing in the evidence has come out to prove that the accused person in question is indeed involved in such involved in the alleged case of drug peddling. The Learned Counsel has also submitted that the accused person is a young man of 20 years old, and in the event he is acquitted in this case, precious time would have been lost and his career and his future would be affected as a consequence thereof. Accordingly, it is accordingly prayed that the application for grant of bail may be allowed and the accused may be enlarged on bail on any condition as deemed fit and proper to be imposed by this court. Where contra, Ms. N.G. Shila, Additional Senior GA, has opposed this prayer made in this petition and has submitted that the records as well as the evidence adduced in this case has clearly brought out the fact that the accused person in question is indeed involved in a case of drug peddling. The fact being that he is a supplier of drugs and had close connection with the other co-accused, wherein in the process of one such business negotiation, which when Ori, the accused person, was allegedly kidnapped. However, he has reiterated that the fact remains that the evidence of reliable witnesses would show that based on the investigation carried out, it is clearly it has been proved that the accused person is involved in the activity of drug peddling, and as such, at this stage, and as such, the plea made for grant of bail may not be allowed. This court has considered the submission made by the parties and on consideration of the submission made by the learned counsel for the petitioner as well as the learned additional senior GA, what could be understood is that the accused person in question has been implicated in this case primarily on the ground that the alleged contraband drugs was seized from the vehicle in which he was found to have from the vehicle in which he was present at the time when it was intercepted. From the said vehicle, seizure of the alleged contraband drugs was made, and the formalities and procedure involved connected to such seizure has also been duly complied with by the police. It has also, from the evidence of the witnesses, what has been revealed is that one of the co-accused person who was suspected to have kidnapped the accused person in question had revealed that the alleged contraband drugs was brought into the area by the said accused person in question, and he was the person who is said to have supplied the said alleged contraband drugs to them. On this piece of information, the police have accordingly taken necessary action. A bare reading of the deposition made by the prosecution witnesses would show that there is sufficient evidence against the accused person in question on his alleged involvement as far as the drug trafficking angle is concerned. Though it may be too early in the day to come to any conclusion, since the whole of the evidence have not yet been recorded, be that as it may, prima facie, a case has been made out against the accused person in question. Of course, it would depend on the trial court on how the evidence is to be appreciated, which would not be the concern of this court at this point of time. Concern of this court at this point of time. Suffice it to say that on an overall consideration of the facts and circumstances of this case, this court is not inclined to allow the prayer made in this petition. This petition is accordingly dismissed as devoid of merit.
Much obliged, Lordship.
Thank you.
Lordship.
Mr. Pandit, you can come back some other time.